national audience that he deserved more time, that he shouldn't be out on the streets, that he was surprised that the prosecutor for Baltimore City gave him a time-served sentence. At the time, many of us openly asked, is Luther Trent an anomaly? Is he the exception? Or are there other Luther Trents in the criminal justice system? We were assured that Luther Trent was the exception. We filed a motion on behalf of the victims in that case. We got the judge, Judge Melissa Finn, to right that injustice. She hadn't heard from the victims before she adopted the plea deal between prosecutors and defense attorneys. And that, under Maryland law, was a mistake. So she reversed the conviction, rescinded the plea deal, and took Mr. Trent back in custody. I volunteered pro bono to be the lawyer for the victims in that case. And we learned just a few weeks ago that the city is now offering a sentence of 22 years in prison for Mr. Trent. That's an appropriate sentence for 3 counts of attempted murder and first-degree arson, not a suspended sentence. When you do a suspended sentence, what you're saying to the world is that this person is potentially safe to go back on the streets, that we have something hanging over them in case something goes wrong, but that we are confident that justice is served by returning them to the streets of Baltimore. Now, I assume that by offering 22 years after he was taken back into custody, that the state's attorney acknowledges that in the case of Luther Trent, a suspended sentence was a mistake, a big mistake. But how many more Luther Trents are there? How many other violent criminals charged with violent crimes, not low-level offenses, not drug dealing, but armed robbery, carjackings, rapes, first-degree attempted murders, first-degree arsons, and murders? How many other cases like that are there where the prosecutor, for the sake of his or her statistics, for the sake of the office's conviction rate, takes the conviction but sends the criminal back to the streets of Baltimore at our peril? Unfortunately, we learned one answer to that question the hard way. When Austin Davidson, another violent offender charged with an armed robbery, was released, was given a PBJ, and returned to the streets of Baltimore and ultimately Maryland, only to do the unthinkable, to take a law enforcement officer who was trying to serve a warrant and turn around and shoot and kill him. That is what the allegations are now that Mr. Davidson has been charged with the first-degree murder of a deputy sheriff in Wacomico County. The criminal justice system failed Austin Davidson. The criminal justice system failed the sheriff. The criminal justice system failed all of us. But now we have another example of a person who got a PBJ, a probation before judgment, for a violent crime, charged as an adult, where he pulled a gun, pried open the doors at a McDonald's and stole $1,000, at least according to the allegations, and nevertheless was given a probation before judgment. Now, the state's attorney's office's response has been, well, we didn't ask for probation before judgment. Well, now we've learned that what they asked for was a suspended sentence that would have put him back on the streets just as he was. So now we know that even in this case where they're defending what they did, unlike Luther Trent where they didn't even try to defend it, they think a suspended sentence for a violent criminal with whatever history he had as a juvenile was appropriate. So now it's time for us to ask the state's attorney's office to issue us a list of all of those individuals who are charged with violent crimes that were given suspended sentences in plea deals that were approved by the office, who are still on probation in Baltimore City. We know that the state's attorney released a list because she was ordered to, that she maintained of officers that she didn't think were trustworthy. The do not call list was a list that she keeps in her office of all of the officers who are insufficiently trustworthy, that may have concerns around trustworthiness, even in some instances where the allegations against them were not adjudicated. Well, if we keep lists like that, then surely we should have a list of the violent criminals who have pled guilty, who've been returned to the streets on suspended sentences, that could be made public so we know how many and who they are. How many other Luther Trents and Austin Davidsons are there? How many other people charged with first-degree attempted murder and armed robberies, carjackings, were given suspended sentences for the sake of a conviction rate, but at the peril of the public? The deputy sheriff paid with his life for that mistake. We don't need to have more of those consequences without anybody doing anything. We don't have to wait for an election for this. This is public information. I could go on Maryland Judiciary and look up one case at a time who it is that got a suspended sentence for an armed robbery, for a carjacking, for an attempted murder, for an arson. I could go painstakingly find those cases and see who they are. Their names are not shielded because they're not juveniles. The consequences of those cases are not private or held in camera. They are public information. So what I'm asking is for the state's attorney's office to prepare and publish a list of violent criminals, individuals charged and convicted of violent crimes, robbery, carjackings, gun crimes, attempted murders, and murders, who were issued plea deals with suspended sentences, where the prosecutor got the conviction, but the person went home the next day. If you believe that those people are safe enough to return to the public, then you should be comfortable telling us that. We should have a list of those people. We're not looking to employ them. We want to understand how many there are and what their charges were and what they pled guilty to that made you so comfortable that you could send them home. Of course, there are cases where the evidence is weak, where a witness doesn't show up, where there's a concern about the admissibility of a piece of evidence. Any good prosecutor knows the value, the worth of a case. And sometimes a case is strong enough to get a plea deal, but perhaps not strong enough to go to trial. Those are judgments that prosecutors and supervisors in consultation with the state's attorney has to make. And if that happened here or there, that's okay. We would understand that. But if there are dozens, if there are hundreds, if there are thousands of violent criminals who've been given suspended sentences because Miss Mosby cares more about the convictions than about public safety, then at a minimum, we ought to know about that. We ought to know about that so we can take some precautions to make sure we know that those people are back on the streets. Hopefully, they're getting their lives back together. I hope and pray they're provided the apprenticeships and the supervision and the mental health and addiction services and the jobs that they need to build a more constructive path. But how will we know if the state's attorney herself doesn't know? How will the public be able to do what is necessary to ensure our collective safety if we only learn of their names after the sheriff is killed, after the case is dropped, after the victims come forward and say, Luther Trent tried to burn my house down while I slept inside, and you sent him home over my objection. You sent a man charged with an armed robbery who had used a gun in that case. You sent him home only to slay a police officer who was trying to do his job. Last thing. It's a simple request. It's a simple request. We are asking the state's attorney to share with the public a list of those individuals who were charged with violent crimes, who pled guilty to violent crimes, who were given suspended sentences. These are the individuals who were sent home, who were convicted, but were sent home despite being charged with robbery, carjacking, firearms cases, arson, attempted murder, and murder. Maybe there's a few, maybe there's a few dozen. Maybe we could understand that. My concern, now having seen Luther Trent and Austin Davidson freed based on the judgment of prosecutors in the state's attorney's office, is that there may be hundreds, there may be thousands of these people. And if that's the case, the public needs to know. Yes, Jeff?
I'm just wondering what that how that will impact prosecutions. If that's released, will that impact future prosecutions, or is it just for public awareness?
I mean, the prosecutor should be making judgments about what an appropriate plea deal is based on the strength of the case, based on the willingness of the defendant to admit responsibility and take blame, and on the judgment that prosecutors are making about the severity of the case. If a person is 18 years old and got caught selling drugs for the first time, I don't know that the public would be upset with a suspended sentence in that case. That person might even be given a PBJ so that they can get an apprenticeship and a job. That's an appropriate exercise of judgment. But in a case of a person charged with attempted murder for burning down a house, in the case of a person charged with an armed robbery using a gun, in the case of a person committing their second or third armed carjacking, a suspended sentence is not an appropriate plea deal, at least in most cases. Maybe there's an exception, but we need to understand this. And releasing this information shouldn't affect the prosecutorial model unless we're doing it wrong. And if we're doing it wrong, if we're setting free violent criminals so that we can ramp up our statistics at the risk and at the peril of the public, then we ought to change the prosecutorial model. We ought to have prosecutors appreciate that plea deals with suspended sentences are not appropriate for violent criminals.
So you think it'll impact future plea deals then? You're hoping?
If violent criminals are being set free on suspended sentence plea deals, then yes, I hope that that practice changes. And it certainly will when I'm state's attorney.
I'm wondering about the release of, you want them to release information of people convicted of violent crimes but are released on suspended sentence or plea deals?
Correct. Very simple category, right? If a person is charged with an armed robbery and they receive a 3-year sentence, they have served 6 months, but they still have 2.5 years to serve, I'm not necessarily asking for those. There's a very specific set of cases where you offer them time served, which means they plead guilty, they sign off on the paperwork, and they walk out the next day. Those are the people that I want to make sure are the kind of people that we want to have plea deals of that variety. Because understand the psychology. If you're a defendant like Luther Trent and somebody says, you can go home tomorrow if you plead guilty today, Luther Trent faces life in prison for 3 counts of attempted murder. You're going to take that deal and go home. In the court transcript, Mr. Trent said to the judge, you don't have to tell me twice, I'll take that deal. Well, that's what suspended sentences run the risk of, because defendants are ready to jump on that because they get to go home. There's no evidence that they're taking real responsibility, that they've reformed their ways, that they're ready to go home. All it means is they want to go home and they're being given a ticket home, and all it costs them is for them to sign on the dotted line that they did what they're charged with. So those cases where violent criminals like Austin Davidson, like Luther Trent, individuals who are charged with robberies, carjackings, firearms offenses, attempted murder, arson, and murder, just those categories of crimes, we want a list of those people that are still on probation that were given suspended sentences. Maybe it's 5 people. Maybe it's 10 people. Maybe Luther Trent and Austin Davidson are 2 of the 10. My fear, the public's fear, is that they are the tip of the iceberg. And the only way for us to find out is with full transparency, with full disclosure. We're entitled to this information, it's public information, and Marilyn Mosby has it. All we're asking her to do is to publish it so that we know that the judgment her prosecutors are exercising reflect the will and the safety of the public.
Do you have any indication that if this is happening in great numbers, if it's because of the inexperience in the office or because they don't want to go to trial and they're just willing to negotiate anything just to relieve themselves, or is it a theory, is it a philosophy that they have?
Yeah, look, it's a great question. In this particular case of Austin Davidson, you heard the prosecutor saying, well, this individual can't even get the resources that he needs, so that's not his fault. That's the argument that the defense attorney should be making, not the prosecutor. And so when the judge says, I'm prepared to give him a probation before judgment, when you yourself have started your negotiating position by saying, I'm going to give you a suspended sentence, that doesn't give you much room to negotiate. Whether that's a reflection of temperament or philosophy or policy or inexperience, I do not know. I just know that decisions like that have catastrophic consequences, like what unfolded in Wicomico County on Sunday. If Ms. Mosby, if the state's attorney doesn't release this list, it begs the question, how many other Luther Trents and Austin Davidsons are out there? If you're reluctant to share the plea deals for violent criminals with suspended sentences, it will give the public the impression that you're not proud of your record either. One of the reasons we need to know is because we're entitled to this information. One of the reasons we need to know is because we need to make sure that violent criminals aren't being sent home as a matter of course to raise your conviction rate. But one of the reasons we need to know is so that we can take the necessary steps to protect ourselves and to protect our communities, to make sure that Luther Trents and Austin Davidsons are not roaming free. In the case of Luther Trent, when we learned about it, we did something about it. We got Luther Trent back behind bars. I was a private citizen helping some victims out pro bono, and we were able to convince Judge Finn that a mistake had been made and that to rectify that injustice, Mr. Trent needed to be taken back into custody. How many other Luther Trents need to have a measure of justice brought to them? How many other Austin Davidsons on open warrants are roaming free without the public knowing what they're charged with? That deputy sheriff, he knew the risks he was running. He knew he was trying to serve a warrant, but he has no way of knowing the record of Austin Davidson, what Judge Finn had told him. He had no way of knowing that a gun was involved in the prior conviction. He had an open warrant, and he was trying to do his job and serve it. We have to have this information, because if the state's attorney isn't going to protect us, we're going to need to make sure that we have a change in policy, either at the ballot box or in policy, to make sure that we are safer than we are right now. Thank you, everyone. Thanks for coming. See you soon.